Institute. Today's Today's welcome remarks are going to be given by Chief Judge Rebecca Pallmeyer of the U.S. District Court for the Northern District of Illinois. She is a graduate of Valparaiso University and received her law degree from the University of Chicago Law School. She was appointed as a magistrate judge in 1991 and was confirmed as a district court judge in 1998 for the Illinois Northern District Court. She was sworn in as the chief judge in 2019, holding the honor of being the first female chief judge for the Northern District of Illinois. Thank you, Chief Judge Pallmeyer, for joining us today.
Thank you, Lauren. Good morning to everybody here and welcome to the United States District Court for the Northern District of Illinois. I'm sorry I'm not with you in person. If we were conducting this program in the Dirksen Courthouse, we would be doing that in the ceremonial courtroom, which is a large, grand room with photographs on every wall. On the wall that's behind the bench of the building are photographs of judges who served our court and have now died, including Judge John Grady, who I'm going to talk to you about for just a moment. On either side wall are photographs of the current active judges of our court. And on the back wall, the wall that we face when we're sitting on the bench, are photographs of judges who've served our court and have now moved on either to retirement or to another position in the federal district court or the Court of Appeals. I myself am Rebecca Pallmeyer. I'm the first woman to serve as the court's chief judge. My service as the first woman reflects the opportunity of our nation and what the liberties that the Constitution guarantees should mean for all of us. I'm going to talk to you for a moment about one of my predecessors, Judge John Grady, who served as chief judge of this court many years ago. Judge Grady was referred to as a Lincoln-esque man. He was tall, quiet, dignified. He served as a United States federal prosecutor and then conducted a sole practice in Waukegan, Illinois. He was a courtly and dignified presence in the United States courthouse, known for his commitment to integrity. Judge Grady is recognized for many things, including the harsh sentences that he imposed on public officials who were found guilty of accepting bribes. He did that in 1977 case involving the Water Reclamation District and a 1982 case involving Chicago police officers. But as you will hear, one of the most important roles that Judge Grady served was that of a teacher. Your students take notes and ask questions when they're in class and when they're engaged. Judge Grady thought jurors were entitled to do that too, and he was the first member of this court, one of the first judges in the nation, to permit jurors to take notes during their trials, and one of the first judges in the nation to allow jurors to orally question witnesses themselves in civil trials. He wanted the jurors to understand and learn, just as we, when we teach students and children, want them to understand and learn. I visited his courtroom myself to learn about jury trials when I was a new judge. I watched the judge that the court reporters told me was the best, and he really was. Good teachers inspire loyalty and love on the part of their students. I know you teachers have had that experience of having students come back months, sometimes years later, to thank you for the work that you did. Judge Grady's students were all of his law clerks, the young recent law graduates who came to work with him for a year or two after law school and to learn what it was to practice law in the best possible way. Like so many of your students, Judge Grady's law clerks will never forget the education that he offered them. They funded this program, which will continue his memory and legacy in such a perfect way, assisting another generation of teachers as they assist a generation of students in understanding the universe, the world, this nation, the United States Constitution, and the rule of law. Helen Caldecott said, "Teachers, I believe, are the most responsible and important members of society because their professional efforts affect the fate of the earth." And I believe that's true. Our court thanks you, teachers, the so often unsung heroes of our society. Among the many things you teach your children, today we hope to put tools in your hands for teaching them that the Constitution has an effect on their daily lives. The Constitution guarantees so many of the things that they take for granted, that they can go online, read books and newspapers, talk to their friends on the phone, get an education, not be forced to work, and have any religious belief or no religious belief. When they get older, they'll learn to appreciate, we hope, the right to vote, the right to free speech, the right to privacy, and the right to feel safe and secure in their homes. The Constitution begins with the words, "we the people," and our children will be the people who determine the fate of our country. Our Constitution, indeed, our democracy is a fragile thing. But when students are well educated, when they understand the Constitution, when they're committed to the principles of the Constitution and the world of law and the rule of law, we can have confidence that our democracy will continue. I wish you very well during this program. I hope it's a good one for you, an interesting one for you, and that it puts new tools and ideas in your minds as you return to teaching this fall and to shaping our children's minds and their hearts in the future of our nation. Thank you again for all that you do for us. Best wishes to all of you. Thank you.
Thank you, Chief Judge.
Thank you, Judge. I really appreciate those opening remarks. So we are gonna, I think, get started jumping into our case studies. I'm gonna change my view. Give me 1 second. There we go. I think we might have had a mix up on, since we started the time early today, have not quite as many teachers on as we had hoped to start, but we have one from each case group at least, so that's great, and we can get started with the jigsaw. Rather than having you guys go into your small groups, we are already a small but mighty group. And so I was going to ask someone from each of the groups to present on the cases that were assigned to you guys for the jigsaw, and I'm going to go ahead. I think we'll stop recording for this portion just so it's not like weird and people don't feel like they're on pressure or anything. I'll pause it.
1978 to 79, very early in the judge's long tenure on the federal bench. After his clerkship, Mr. Bowen joined the U.S. Attorney's Office here in the Northern District of Illinois, where he spent 5 years in the criminal division prosecuting a wide range of federal offenses, including tax evasion, public corruption, and commodities fraud. Mr. Bowen then moved to the private sector, where his practice over time came to focus on private civil litigation and regulatory investigations and enforcement proceedings arising out of the trading of securities, options, futures, and other more exotic financial instruments. Mr. Bowen retired late last year. He was instrumental in securing the funding to start the Judge John F. Grady Teacher Institute. Welcome, David. Thank you for being with us here today.
Thank you for allowing me to participate in this inaugural institute. And let me just begin very, very briefly with a personal comment. I listened to Magistrate Judge Fuentes's opening remarks, his introductory remarks at the start of the institute last week, and so much of what he said resonated with me, as we are both former clerks of Judge Grady. And I couldn't agree with him more, both how fitting and how important it is that this institute help to perpetuate Judge Grady's legacy. So we're joined this morning by 3 members of the federal bench: Judge Diane Wood, who's the Chief Judge of the United States Court of Appeals for the 7th Circuit; Judge John Lee, who's a district judge sitting in the Northern District of Illinois, which includes Chicago; and Magistrate Judge Gabriel Fuentes, who is a magistrate judge also in the Northern District. We'd like to hear, I want to do as little talking as possible and hear as much from the members of the panel as possible. So why don't we begin by asking each of the 3 judges, if they would, to speak very briefly about their own professional biography and how it is they came to be members of the federal bench. We'll go in alphabetical order. Why don't we start with you, Magistrate Judge Fuentes?
Thank you, David. So I began my professional career as a newspaper reporter, and at some point I decided that I wanted to be more a part of the activities that I was covering, because as a reporter you never really can be much of a participant in anything except reporting. And so that led to going to law school, working at a big law firm, and also as an assistant U.S. attorney, as David did. And then eventually, after 25 years of all of that, deciding I wanted to go back to public practice or public service, and I wanted to, be a part of something different and something bigger than myself, and I was very, very, very fortunate to have been selected. So that's how I landed here.
And Judge Lee?
Good morning. I guess similarly, after law school, I joined the Department of Justice in the Environment and Natural Resources Division as a trial attorney there for a while. And then I'm from Chicago. I was raised in South Korea, came to Chicago when I was 4 years old. And Chicago has been pretty much my adopted hometown. After being in DC at Justice, I came back to Chicago and went into private practice, was in private practice litigating basically large civil cases of all types for about 20 years before joining the bench now a little bit more than 9 years ago. Time has flown. So that's kind of my story in a nutshell.
And Judge Wood?
Yes, well, first let me thank you for including me here. And I do have to make one tiny correction. I'm in the happy position of being the former chief judge of the Seventh Circuit as of approximately a year ago. Our chief is now Diane Sykes, who's doing a fine job, but I've been on the Seventh Circuit for a very long time. I bounced around and did a number of things at the beginning of my career. After I finished law school, I clerked for a couple of years on the Fifth Circuit and at the Supreme Court for Justice Harry Blackmun. I then went for a little while to the Office of the Legal Advisor for the U.S. Department of State, where I worked on economic and business matters, bribery, transfers of technology, and so on. And after that, I was in private practice for a while at Covington in Washington. And I told Covington when I started, I think I really am probably going to want to be a law professor, if that's okay with you. And they said, sure, that's fine. So in 1981, I moved to Chicago and became a member of the faculty at the University of Chicago Law School, where in one guise or another, I have taught forever. I'm still teaching. I'm going to do civil procedure this fall there. In 1993, I took a leave of absence and went back to Washington to the Department of Justice's Antitrust Division, where I was the deputy in charge of appellate work, in charge of legal policy, and perhaps most prominently in charge of all of our international enforcement, which was just a wonderful job, fascinating all the time. But it was from there that I was appointed to the Seventh Circuit in 1995. Talk about time flying, John. I can't believe it's that many years ago.
Judge Wood, thank you for that correction and clarification. And I now know that I am fully retired because in my long professional practice, predominantly in the federal courts, I don't think I have ever been corrected by a federal judge.
Oh, well. Only in a friendly way.
Let me ask, because we have here sitting on the panel an appellate judge, a district judge, and a magistrate judge, let me ask each of you, if you will, to describe very briefly where within the structure, the overall structure of the federal judiciary, you fit and how that affects what you do on a day-to-day basis, sort of your daily duties and responsibilities. Why don't we go in reverse order this time? Judge Wood?
Sure. Well, as we all know, both by constitutional design, and this is just the way it is, our federal judiciary is headed by the Supreme Court. It's the only court that's mentioned in the Constitution. One Supreme Court and such inferior courts as Congress may decide to create, roughly. And Congress did create a full-blown system of courts that stands side by side with the state court systems. And the level just below the Supreme Court are the courts of appeals. And we have 11 regional circuits. We're in the Seventh Circuit, Illinois, Wisconsin, and Indiana. And we have the DC Circuit and the Federal Circuit. So there are 13 federal circuits. We are usually the last stop. I like to say to people, out of, say, the 2,700 cases that come each year before the Seventh Circuit these days, the Supreme Court's likely to look at 5. Most of us know which 20 the 5 are going to come from, but that's not very much review. So I approach every case as though I'm going to be the last word, even though obviously that's not true. And we are obliged in a hierarchical judicial system to conform our rulings to what the Supreme Court has told us to do. And that's very important, and that's a big part of our job. But our opinions are precedential within the 3-state area that we cover. And we take that responsibility very seriously.
Judge Lee, the role of the district judge within the overall federal system?
Certainly. So the district judges, we're the trial judges. And so when you think of trials, both civil and criminal proceedings, all the trials happen in the district. Most of the trials happen in the district court. And the district court is, on the criminal side, we handle many of the preliminary proceedings. We oversee the case, and then we end up being the trial judges for the case. I just finished a 3-week white-collar criminal case trial involving securities fraud. And our cases involve anything from that to large antitrust cases to individual civil rights cases that raise various constitutional issues. And so our decisions are, when they're appealed, are reviewed by Judge Wood and her colleagues on the 7th Circuit. Let's see, what else can I say about district court? The way I think of the district court is we're kind of where, when the public thinks about a trial court, that's kind of the work that we do. When you think of testimony that's given, or judges that make various rulings on various motions. So we kind of handle the nitty-gritty. Sometimes I like to say we're kind of the conductors at a train station. There are lots of cases being filed, and we kind of oversee how they are resolved and how they happen. Some of them are appealed, most of them aren't. Most of them are settled, actually, or resolved, or somehow other disposed of. But that's kind of the day-to-day work of the district judge.
And Magistrate Judge Fuentes?
So unlike Judge Wood or Judge Lee, we magistrate judges are not appointed for life. We're not appointed by the president. We're appointed by the members of the district court. And we really exist to support the district court. The district judges have tremendously busy dockets, and the cases involve some fairly involved disputes, for example, over discovery and what materials have to be produced, what materials are protected from production by privilege or are too burdensome to force someone to produce. These things come up very, very frequently. And if district judges had to deal with all of them all the time, it'd be very hard for them to do their jobs. So the Congress created magistrate judges. We serve 8-year terms. Our term is then renewable on reappointment by the district courts. And we take these matters from referrals from our district judges. Here, Judge Fuentes, you are referred to manage discovery in this case. And then I handle all those motions. And if one party doesn't like my decision, they can take that up with the district judge through an objection process. Another thing we do quite a bit of is mediation. So we take referrals for settlement, and we become the peacemakers of the court. And we try to aid the parties in understanding that there's a reason why 96 to 99% of cases in the federal system settle rather than go to trial. The settlement often is better for everyone, and we aid that process. That's a great benefit to the district court as well. The other thing we do is in criminal cases, we manage the very beginning of the process when the prosecutors come in ex parte, under seal, secretly, because they're conducting an investigation. And the facts of that investigation, no one's yet been charged, can't be disclosed publicly. And they need a search warrant or they need some authority under the 4th Amendment to invade someone's privacy. And we determine whether that's okay or not. Then later, when someone's arrested, we will hold the initial hearings for them, advise them why they're here, and determine if the government wants them detained. A big deal, big impact on an individual to be detained, should they be detained under the law. That's essentially what we do.
Thank you. The teachers who are participating in this institute have been exploring the First Amendment's right the rights guaranteed to citizens under the First Amendment, specifically to assemble and associate. Let me ask, why is understanding the scope of the First Amendment and how it is implemented, why is that so important? And perhaps in answering, are there any, in your experience, are there any sort of common misunderstandings, widely shared misunderstandings or misperceptions about what the First Amendment does and does not do? Judge Lee?
Sure. I think the reason why it's so important to understand and appreciate the First Amendment is that free speech and association assembly, I think, are one of the cornerstones, if not the cornerstone, of a democracy. This is how people carry on public debate, and this is how people decide on who their leaders will be or what issues are of import to the republic that we should discuss and try, and to the extent there are any disputes, try to resolve. It's also, I think, important as a matter of what I would say a public discourse with regard to disputes, with regard to issues where people disagree, with regard to how to deal with things either politically or otherwise. And so I think when I think about the First Amendment and kind of the role it plays in our country, in our republic, that's what I think of first. With regard to misconceptions, I think that there's so many interesting First Amendment cases, right? They're percolating out, not only in the courts, but just kind of in our public discourse and domain. Facebook is a great example of that, right? Or how Facebook or all these other tech companies are quote unquote dealing with or regulating speech. And I think one of the common misconceptions I find in the media and just talking to people about it is they think is the fact that the First Amendment really restricts or prohibits government actors or state actors from impinging upon speech, right? It doesn't really say much or anything about private actors, and that the debate between what constitutes a state actor, a public actor, and a private actor, I think, is something that we're all going to be grappling with for some time, given the dominance and the prevalence of private social media companies in our country and in the world.
Judge Wood, in your experience, are there common misunderstandings, and why is it so important that they be cleared up?
Sure. Well, I'll take it in that order because I entirely agree with what Judge Lee just said. I think really for quite understandable reasons, people don't appreciate the fact that at its root, the First Amendment was a restriction against public censorship, a restriction against public actions that impinged on the various rights that are enumerated, the right to speech, press, right to assemble. We'll put the religion clauses off to one side. And so people don't see that as readily. On the other hand, these are blurry lines, and the public is absolutely right to be scratching its head because we're doing the same thing. For example, the Supreme Court just had in the Hasid case, the question whether a union organizer can go onto private property to organize workers. And the court said, no, private property is private property in essence. And you can stand at the doorway if you want, if you're out in the public street, or at least metaphorically the doorway, but you don't have any right to do that. Well, what are we going to do with Facebook or Twitter, which are technically, of course, and in reality, private entities? But if that's where all the speech of the day is going on, could, for example, Congress pass a law treating them like public utilities, saying that you need to allow access on reasonably compensatory grounds, and you need to be non-discriminatory on the basis of a number of factors in who has access? Or would that be too much of a restriction on their free speech rights? I don't have the answer to that question, but that is going to be preoccupying us, I'm sure, for quite some time to come. We don't expect, to take a physical copy of the New York Times and to be able to call the Times up and say, you have to accept ads from this advertiser, or you have to publish this guest editorial, or you have to do this or that. People would say, well, of course not. They get to choose what they want to put in their paper, but it's not so easy. And there are many other areas where, including in these cases that you've given the teachers, where you can see these tensions. What if somebody's advocating violence? What if, to take the Schenck case facts, what if there is such an interference with access to private property that people who want to go into an establishment, we can just flip the facts around. Suppose it's a gun shop that's selling lawfully various types of legal guns, and a group that's very anti-gun wants to blockade the door to that shop. Well, are we going to have the same idea about a 15-foot buffer zone? Are we going to say, we need, as a practical matter, to make sure that people can go in and make their lawful gun purchases? I mean, these principles, and we're always thinking about this, how do they apply in the next case, and the next case, and the next case? We can't just stop with the facts in front of us and then suddenly the next case comes along and say to ourselves, oops, we didn't realize that this application was going to come along. So these are very tricky issues. It's not at all surprising that the public has trouble with them, because so do we.
And Magistrate Judge Fuentes, do you have anything to add here?
I would just add an observation from my practice managing civil discovery. There are quite a few members of our legal community who don't fully understand the public nature of the court's business, and that when they submit a document to have us make a decision, and they have facts, exhibits, arguments contained in that document or attached to it, they will often move to seal those materials because they're covered by a protective order, which prohibits its use in other matters. But the assumption seems to be that if this material is confidential, that the public can't see it, but they can, unless there's some basis for protecting some privilege or some other interest. And so there's a very sort of casual view on the part of many lawyers and some judges about the presumptively public nature of judicial proceedings that I wish we would maybe fully realize a little more.
Judge Wood just spoke about the hypothetical case in which someone was advocating violence. And in this institute, one of the cases that the teachers have taken a look at is the Village of Skokie case, in which a neo-Nazi party planned to and sought municipal permission to assemble and conduct a rally and march in the village of Skokie, communicating a message that was deliberately provocative, especially in light of the significant Jewish population in that village. And among the topics, among the issues that that case and the others have raised is the balancing of protecting fundamental rights under the First Amendment, the right to speech, the right to associate, the right to assemble, with a community's legitimate interest in the safety and security of its residents. I'd like to hear from each of you, if you will, concerning the role of the judiciary in performing that balancing that's required. Does anyone want to take a stab at that?
I'm going to nominate Judge Lee, because the way these cases reach the judiciary usually is by somebody going to a district court judge initially and saying, please issue an injunction that says something. So, Judge Lee?
I'm happy to take it up. Well, I would start by saying that these cases are very fact specific. And so it's hard, I think that I have a lot of admiration for Judge Wood and her colleagues, because they have to try to think about all the different possible scenarios that might come up when they rule on a case. But for the district court, I'm really dealing with a specific case, right? And the specific facts of this case. And I think that the context matters, the exact message matters, and the interests that the community is trying to protect matters. So it kind of brings to mind in some respects, and I forget what the name of the case was, but it just came down from the Supreme Court, the cheerleading case, right? Where the cheerleader posted on social media, and I forget whether it's TikTok or Instagram or one of those platforms, something derogatory, although not threatening, but derogatory about the school and the way she was treated. And the question was, of course, the school banned her from being a cheerleader, and she challenged that all the way to the Supreme Court, right? And the schools said that, as I recall, that its interest was protecting the integrity of the school and the safety of the community. And they parroted all of these things that one would typically hear in a case like that. And the Supreme Court and the lower courts basically looked at how legitimate those interests were, right? How real were those interests of the community, and how problematic was the speech, and how really threatening was the speech in that particular context. And so I think that at a district court level, I guess I'm less concerned about making broad principles of law and broad pronouncements, because I think primarily my role is trying to weigh the interests in that particular case. And so I think the role of the court is particularly where issues are very heated, where the interests of the community are often very, I guess, they're very vocal, is making sure that the reasons that the community or the public state actor gives for what they do, whether there's a legitimate basis behind that interest. And I think that's one of the key roles that judges perform, is just not taking things for face value, but actually looking into it and saying, okay, well, you think that this tweet or whatever is threatening. Why do you think so? Why do you think it's important to regulate that type of speech? So I think in my role, I just try to make sure that all of the positions that people state in the public, either in the media, what have you, have an actual factual basis for them.
So if I heard you correctly, then in the first instance, the balancing that's required under the case law, or the application of some level of scrutiny to, for example, a village ordinance, that function is performed initially at the district court level, subject to review by the appellate court, including Judge Wood. Is that fair?
Yes, that's a fair statement.
So few cases reach the Supreme Court, and for that matter, relatively few cases result in a published decision by the Circuit Court of Appeals. So let me ask, are there any very recent or very noteworthy cases that we might not be aware of coming down from the Seventh Circuit or the District Court in the Northern District of Illinois that involve First Amendment rights that any of you would like to share with us?
Well, there's one case that illustrates well this point about injunctions and intervening early, because sometimes when first the district court and then the Court of Appeals gets a case, they're just being asked to preserve the status quo while time is spent finding out those crucial facts that Judge Lee is talking about. You don't always have them all neatly tied up in a package, certainly not at the district court level. We operate on the basis of the record that the district court created. So in our case, it is what it is. Sometimes good, sometimes not good, but they do the best they can given the time frame. But we recently issued an opinion, I guess it was the beginning of this week, dealing with the appeal from a district court's decision that Indiana University's decision to require all of its students to get the COVID vaccine didn't need to be suspended while the legitimacy of that ruling was there. And people have all sorts of reasons that they're advancing in these cases. Some of them deal with their religious beliefs. Some of them deal with, you know, I just don't want to be forced by the state to do this, or you're contravening my beliefs. I mean, there are all kinds of things people say. And they will be investigated by the district court judge, and the district court judge will rule on them. But what the judge said is, for the time being, I don't see enough merit in your case to tell Indiana University that they have to suspend this. So the district court judge allowed this mandate to stay in place. They took a quick appeal to our court. We have standing motions panels that are put into place 6 months in advance, so it's impossible to judge shop. And by the way, we always sit in panels of 3 unless it's the full court, in which case it'll be soon, well, it'll be 11. We do now have 11 people. But it'll come right away to our court, and our court did take that Indiana case and say, we don't see any reason to upset the status quo either. It's not a ruling on the merits. It's a very fine line, but it is an assessment that the people attacking the state university's decision haven't come forward with enough. And the other thing you're doing all the time is you're essentially saying, who's going to be hurt more? Is it going to be worse for the people who are opposing this ruling if they have to comply with it for a while? Or is it going to be worse for the people, for the state university, basically? Are they going to be more injured? These are very fine, factually based decisions, but they are, in fact, in the end, rooted in the law.
So, David, if I might just chime in for a second with regard to the COVID restrictions. I did have one of the COVID restriction challenges to Governor Pritzker's restrictions, and it was filed by a church in the district. And just to kind of go into the investigation, or the factual inquiry rather, that happens in district court, you know, people, I asked for a presentation of, for example, the floor measurements of the church, how far the congregants would be separated if the services were permitted to proceed, and just a lot of other discovery that actually a magistrate judge was really instrumental in helping me with. And so it is very, I think, fact intensive, and this balancing that Judge Wood talked about is really kind of critical to that analysis.
Before we open up for questions by the teachers who are attending this morning, let me ask if there is a single message that you would want these teachers to take away from this institute regarding the rule of law or the role of the federal judiciary in interpreting and enforcing the First Amendment, and having in mind that they will then be communicating this message to their students, what would that single takeaway be? Magistrate Judge Fuentes?
Well, a great question. I would say that the federal judiciary really stands at the intersection of the exercise of government power, and that power may affect our free speech rights, and the citizens to whom that exercise of power is directed. And we, I think, really, as federal judges, have a responsibility to bring intellectual curiosity to that, to listen to both sides, be fair, not decide until we've heard all the arguments, and to understand that the rule of law is a principle that is more important than someone's personal or political interest, and that our country, our Constitution, is founded on that. And so that's part of the federal judiciary's job, is to ensure that the rule of law comes first before some other, individual thought or idea, is what I would suggest to you.
Judge Lee or Judge Wood, do you have any thing you want to add or offer?
Well, I would add that even the cases that you've given the teachers, and there are many more that could be added to that group, show that the First Amendment, going back to your first question, is of such central importance to our system of government that we are willing to pay a pretty high price for it, whether it's the marching in Skokie, which was very painful to the people who were Holocaust survivors, but the value of free speech is extremely high, whether it's a case that you may remember called Snyder against Phelps, where the Westboro Baptist Church was picketing the funeral of a young man who had died in the military, not because of anything he had done, but because of their views about homosexuality. And the Supreme Court said, this is offensive, but free speech has to prevail. Case after case, even though it hurts, even though, say, maybe it requires a lot of police protection downtown, whatever it is, we pay a price for it, but it is that important.
And the last thing I would add, kind of jumping off of that really important principle, is when I have two kids, and they're both, well, one just graduated from college, the other one's in college. When we talk about some of these First Amendment cases, the first thing I ask them is, when they talk about how a person who says something they disagree with, that their rights should be restricted somehow, or they shouldn't be allowed to say that, the first thing I tell them is, well, what if the view they were expressing is something that you totally agreed with, right? Would you want the same restrictions and imposed? And of course, their reaction is, well, of course not, because they're right. And my response is, well, it's right to you, right? And I think that notion that the First Amendment really is should be content neutral, right? In other words, it's really valuable to respect the rights of those with whom you disagree, because that's how you will be treated when you try to engage in public discourse, I think is something that is very important.
Thank you for that. I see that we still do have a few minutes. If there are questions from any of the teachers, please ask them now.
I had a quick question, and sorry if it's too specific, but does the rule in Skokie, I think that Skokie said that part of the reason that the court was willing to deny the injunction there was because they allowed for it, the rule required an immediate appellate review, that it was going to be reviewed so quickly that there wasn't a huge burden by grant if you were going to grant an injunction, it could be reviewed immediately, and therefore the burden wasn't so high. But is that still a rule, or was that was that part of the ruling, or is there a different rule now?
Well, I would say there's no formally different rule. We do, as I was alluding to with the Indiana COVID case, have procedures in place to move very quickly if that's what we need to do. And whether it was all the people who were being executed on federal death row last summer, sometimes the stakes couldn't possibly be higher, but we kick into gear and take care of it. There are, in fact, a whole set of rules about how much needs to be wrapped up in the district court before you can come to us. It's called the final judgment rule. And essentially the district court's got to be finished with it usually. In the case of injunctions, though, you can come directly to the Court of Appeals, or for that matter, if you don't like what we did, you can ask the Supreme Court to intervene, see what they do. So the formal structure is still the same.
Thank you.
Do any of the teachers have other questions for one or more members of the panel?
I have a teeny tiny question. I think it was interesting that you mentioned that social media, a lot of the speech and conversations and dialogues that people are having are happening largely on social media platforms. So I don't know, I kind of was like thinking and mulling it around in my head over how social media is treated by the courts. And it kind of reminded me of a couple cases where, I don't know, when we talk about social media, we kind of attach it or relate it to the press, because the press informs, you know, it reports. There's this notion of freedom of the press, but there's also this notion of freedom, you know, of the 5 freedoms in the First Amendment. So, and largely when looking at some of the cases that have moved through the federal court system, like the New York Times case and the Post case, I think in one instance, the court said, no, you couldn't report. And in another instance says, yes, you could. And I think it dealt with the Pentagon paper case. I'm just wondering, is social media considered more so press or under the umbrella of First Amendment or both? And, you know, this is the question that was posed to us when we were examining these cases, is like, which right is more important than the other, I guess, is my question. Should social media be treated like
tackle
press?
that one?
I'm just going to say it's an evolving area because, you know, talk about square pegs and round holes. I mean, we have laws that were written in the late 18th century, 1791 to be exact, for the First Amendment. And it was in draft form for James Madison before that. And I'm really quite confident he didn't foresee Facebook or Snapchat or Insta or anything else. So figuring out how these crucial methods of expression should be treated is going to be tricky. I'll just throw one more monkey wrench into it. We do have, since the 1930s, an agency, the Federal Communications Commission, that has regulated methods of communication. You know, it has broadcast licenses, it has allocated the spectrum to various people. And so we are not in a simple situation where there's just a yes or no answer. We are in a nuanced situation, and we're going to be working our way through it, I'm positive, for some time.
Well, I think we've run out of time now. Let me thank the members of the panel again for your time and attention this morning. And I guess, Lauren, I'll return the floor to you.
Thank you, David. Great job, everyone. That was really good to hear from everybody on the subjects. Kathy, I think that are we going to take a break, or do you want to just go right back into talking about our jigsaws?
I think we'll take a break. I just want to say on behalf of the American Bar Association, thank you to the judges for joining us today and speaking with our teachers. I know I got a lot out of it, and I'm sure they did as well. So to our teachers, I've got 2 minutes past the time in my time zone, past the hour in my time zone. So I think we'll do a 5-minute break, come back, finish the jigsaws with Jeannie and Jennifer's presentation, and then we'll move into Mary Ellen and classroom application. So we'll see you at, well, now it's 3. So we'll see you at 08, whatever your hour is. Thank you to our judges.
Have a great rest of the day.
Thank you again.
Thank you, judges. Did any of the judges, if they had just a moment, a couple of us as classroom teachers are watching Tennessee very intently with the, if you teach this, you can be fined, talking about CRT, and even related to CRT, if you make your students feel badly, I think is the wording of the Tennessee law. So I don't mean to hold you over, but I'm just like, will that be a First Amendment issue for teachers? Will they be seen as a government actor? And therefore, I just, it's got my head spinning a little bit that these laws are being passed.
I mean, I'm just going to say I would prefer not to comment on it because they are being passed, and I don't like to say anything if I think it might come before me.
Definitely. I respect that very much. Thank you.
Tracy, if you want, I would be happy to email Dean Chemerinsky and get his quick view on it and see what he sends, and then I can send that out to the group afterwards.
Awesome, that'd be great.
Okay.
Thank you. I'll go take a break.
Okay.
Thank you.
Do we want to pause again? Recording?
Yes, thank you.
Did you want to go first, Jennifer? I didn't know if you, because you have to switch off, or what would you, or we could just chime in together, I guess. I think you're muted.
Jennifer, you're still muted.
If I do that, I think you guys are getting an echo though. Okay, I'll just use the one device. Is that working? You guys can hear me? Yeah. Okay, how about if I go first, then I can say I participated in my part. Does that work? Okay. I apologize. We go back to work next week and I'm trying to shove everything in this week, getting things done. I'm sure everybody knows how that works. So I'm going to take the, I hope how do you say it? Dejean?
I believe it's Dejean.
What again?
Dejean.
Okay. Versus Oregon in 1937. He was speaking at a Communist Party meeting, and part of his speaking about against there was a strike, maritime, not against, but in regards to a maritime strike, and what was happening in the local jail. The Portland police came in and arrested him under the idea, or the state law, that this group advocates crime, that this group advocates physical violence, this group advocates sabotage and unlawful acts. And he's arrested because of this idea that communists advocate these kind of things, not necessarily that he was saying we're going to go do all these violent things. Eventually, the case does appear to the Supreme Court, and the court rules 8-0 in his favor, saying that his just talking was not against the law, that essentially being a communist wasn't against the law, that there was nothing really stated that he was advocating going in and actually doing these acts of violence. And that the Oregon laws, working on the assumption that being a part of a group, an association, part of a group, then also advocates possible action. And Chief Justice Hughes had made the statement, mainly the right to free speech and assembly shouldn't be denied simply because of belonging to a group in what was happening there. I'm trying to make this really brief, and I'm going through all my bulleted notes. I should have made a slideshow presentation because it also keeps me on task too. So he had written that these rights may be abused by using speech or press or assembly in order to incite violence or crime, and he was not doing that. He simply was bringing up, like I think it was Judge Lee had told us, the ideas that the First Amendment allows us to express to one another and share to one another cannot be denied simply with the assumption that that group will bring violence. So I kept that brief. I could go on with all my bullet points, but how's that, Kathy? Did I do it sufficient to that case?
You did perfect, Jennifer. Thank you.
Jeannie, go ahead and fill in the blanks that I may have skipped over.
No, I thought that was perfect. And I was just, what I was fascinated by was I said that, it seemed like the Oregon law was something to the effect of, like, if the Communist Party met, and even if they weren't talking about like the strike that was going on, right? And the strike actually was about talking about police brutality too, which I thought that's kind of an interesting tie-in with today too, if you wanted to bring that in when you're talking with the kids. But also that they could have just been talking about foreign policy or tariffs or something, but it's the mere fact that the Communist Party was meeting, you know, that it seemed like it was guilt by association, not necessarily by really what the Oregon law was trying to stop, which was criminal syndicalism, right? So I thought that was what was brought up, right? Or what the law was about. So no, that was it. I can do the second one.
Yeah, Jeannie, if you want to talk
that.
to us a little bit about NAACP,
Yeah.
that would be great. Thank you.
And actually, when I was doing my reading, I did the other case first, and I spent a lot of time on that. So this one is not as fresh, but that's all right. So in this case, the NAACP was trying to set up a branch, and gosh, I'm in California right now, and I have to just say, like, this is breaking news. There's like mist in the air. It's like, oh my God, we have some rain, perhaps. Anyway, so very exciting. So the NAACP was trying to set up a branch or an office or business in Alabama, and they hadn't really officially incorporated there. They were incorporated in New York instead, and Alabama had a statute on the books where if you were like a foreign entity incorporating or working unincorporatedly in the state, that you had to kind of disclose a bunch of documents, and one of the documents would be a list of members of the NAACP. And so the NAACP had provided all of the documents that by Alabama law that they wanted, except the list of members, right? Because they were afraid of reprisal, like listing those members would basically subject, in the eyes of the NAACP, the people on that list to some kind of, whatever that is, violence, possible job loss, whatever, right? And thinking that had happened, or knowing that had happened in the past, right? And so the NAACP, I think there was an injunction filed against them to stop their business, right, in the state, and it wound its way through the court system. And what the Supreme Court decided was that was on the side of the NAACP, saying that the interest of this, it seemed like there was a preemption going on, right? That there was an activity that they were doing or so forth, and you can help me, Catherine, but that just the mere fact of, it's an interesting where they worded it, like it's like the idea of like the state is prohibiting these people from associated, I'm losing it here. Help me with this last part of the case. But the idea is that, of course, the NAACP,
it was almost what we would call like a chilling effect in a different setting.
Exactly.
So that
exactly.
Just asking them to turn in their membership lists would be enough to prevent people from joining the association, and that violated the fundamental sense of being able to associate together. So we use chilling effect in constitutional law in a lot of other settings or a lot of other ways, and this is sort of the main way you see it in this First Amendment right to assembly case, is this NAACP case. Yeah, you're totally right on, Jeannie.
And if
fascinating, right? And then go ahead.
Oh, the part of this was how would we put in classroom practices, and as we were told last week, and our in-between reading was American Prosperity Foundation, and this fits right in with that disclosure of names and lists. And I teach a contemporary issues in political science class. That's why I'm interested in these workshops, because of course court decisions are contemporary, and so where does those intersections happen between past and present and those foundations? So definitely a relation between these, at least I see a relation in these two cases.
Yeah, and that was part of the reason of giving you that as the reading, and I think actually loops back nicely to have this be the final case of the jigsaw, because the court in NAACP, in the majority opinion, spends a lot of time talking about the safety concerns of the members of the NAACP, and sort of the very validating their safety concerns, and then putting that in comparison to, or weighing that against, what the government is asking. And as Jeannie mentioned, they had complied. The NAACP had complied with a great number of the requests of the state of Alabama, turning over board of directors information, their other leadership information, and had done basically everything up until the point of turning over their membership lists. And so the court is saying, you know, Alabama, you've had all this other information. This is enough, and this is where we're drawing the line in the sand. And I think when you compare that to the readings from Americans for Prosperity, you see the court doing that same discussion, right? So they're looking at, why is California asking for this disclosure law? Well, they're asking for the disclosure law to protect fraud in charities and in nonprofits. Okay, so what are those concerns, and how seriously do we weigh those against the individual concerns of the right of association and ensuring people have the ability to associate with organizations and individuals that they want to be grouped together with? I thought it was interesting for them to play around with the sort of the safety concerns of NAACP to the degree that they did, because they talk about the worry that the Americans for Prosperity members and the Thomas More Law Center have about reprisals if this information gets out, that people are members of these organizations, and sort of weighing that against the concerns that the NAACP had. And, you know, they had very obvious concerns about Ku Klux Klan and safety concerns there, but this is a very politically divisive moment in our history as well, and there are genuine concerns there. So to me, was a very analogous case, but with sort of a reverse on the politics of it, if you will, to some degree, and very different. So I think they're really interesting cases to compare and contrast, and do that thematic pull through American history through the lens of the Supreme Court, is really interesting. So I'll just conclude by sort of wrapping it up, and go ahead, Gina. Yeah.
I was just gonna say, in states too, it's like, this is in California, it's considered a blue state, but that would be a victory for, you know, a red, you know, for the right, and the vice versa in Alabama, a red state, victory for the left, you know, in terms of the decisions. So
Absolutely. So what we see with the first two, so Dejean versus NAACP, you see them saying that, first of all, First Amendment rights can be regulated, but we can also put controls and restrictions on what the state government does. And it's sort of not a carte blanche, that they can't do whatever they want, and that there is a fundamental right to association that applies against state action. And then NAACP is sort of I think if you're looking at these cases, one of the landmark cases in this area, and really a foundational case. And it sort of spells out this fundamental question we've been dealing with, of how do you balance individual safety and security and community safety and security against the ability to associate as allowed for under the First Amendment. And then we move into Edwards versus Lloyd, where we see the court dealing with public land and access to government land versus private land. Does it have to be unpeaceful? Do you have to be causing violence? Do you have to be protesting against what that organization, or here the mall, deals with? And then into some of the more modern cases that we're dealing with, so Skokie and Schnack, are really saying, like, we got to have clear regulations. There's got to be procedural safeguards and guidelines. And then we pull it all the way to this March, and what's old is new again. And we are right back to Americans for Prosperity, and the court balancing those sort of fundamental issues again. And I think it's a really interesting, if you do any trainings with the ABA, I like things that, like, Fourth Amendment to me is like a big pendulum swing. This is not a pendulum swing in the same area. It's definitely like a circular, we're going around and we're refining and then restating, and then refining and then restating. And I just think it's a really interesting way to see the court struggling with these issues again and again. And as you have all mentioned, I thought really accurately, we're going to see it, I think, even more so with some of this technology and the social media issues in the next 10 to 15 years. So with that, our jigsaw is finally complete. I hope we see the whole picture and there aren't too many pieces missing. And if so, look in the vents, because that's where they always are at my house when we can't find the jigsaw pieces. Mary Ellen, I'm going to pass it over to you for our classroom application.
All right. So with that, I am going to share this slide deck in the chat with you, and there's also going to be some other things to share with you as well. So whoops, that didn't work out so well for me. So here is the slide deck I meant to share in the chat. Here we go. This will make the cheese more binding. Here we go. All right. All right, so my task that was given to me by Kathy was to kind of think about how we might iterate this knowledge and implement it into our classrooms. So I'm going to have you experience some strategies that help us together as a cohort sort of probe more deeply into this content and some of the questions that are around freedom of assembly, public safety, this tension, the seesaw, as it were, and then also some opportunities for us to collaborate with one another on this as well. So as we shared, myself and Kathy, we both have been involved in creating this Educating for American Democracy roadmap. And so as I was thinking about classroom applications, I really wanted to put the focus on classroom application that really embraces the idea of inquiry as the primary mode of learning, where we're getting students some authentic real world problems. I think this is very engaging for kids right now. This is something that they could see applying to their lives, that we can really get them into active learning and collaboration and work together towards answers and solutions, whether we're doing this throughout a unit or maybe in a discrete lesson. And a lot of us also, I know in Illinois this is true, and I know Jeannie in California this is true as well, is that another thing that really frames the pedagogy we're using in our classroom is the C3 framework, right? That we're to be using compelling and supporting questions to sort of drive inquiry and drive curriculum design. So I'm kind of keeping those things in mind with what we're going to be doing together here. And so, as Kathy, Lauren, and I, and Tiffany kind of talked about what is really the compelling question of the inquiry we're engaging you in the next couple of, these 2 days, it really was this idea of this balance of how should the government balance First Amendment right to assemble and associate with public safety concerns? Like how do they navigate this? And you folks looked at a number of cases, got to ask a number of constitutional law experts, how they sort of navigate this balance, this tension. And so what I want to ask you right now, just kind of thinking as a whole on all the learning that we've done, whether it be with our judicial panel, with Dean Chemerinsky last week, with the cases you just interacted with, even the more recent case that was your homework, what are some of the factors that impact how the government balances the right to assemble and associate with public safety concerns? What I want you to do is use that smartphone that's sitting right next to you, or you can minimize the screen and go to the URL up on the screen, and let's list the factors that kind of go into how the government balances these things. What do they consider? If there's a factor that's like 2 words, like let's say public safety, you could put an underscore between those 2 words to kind of keep them together. And let's build a word cloud of all the considerations that we have to keep in mind as we think about how we balance these 2 competing interests. Great. So the person that put content neutral, they put an underscore as they put that into their phone or the computer. It kept those terms together. So what other factors should we keep in mind here as we build this word cloud out? You can put in more than one item. Kathy and Lauren and Tiffany, I hope this little formative assessment here is encouraging to you. All right, could I ask one of the teachers to unmute themselves and kind of make sense of this word cloud for us? Like, what are you seeing come forward here about what factors impact? If your students put this response into a word cloud, how would you make sense of it?
I noticed the larger word of public and private are both there, as well as immediate, and the idea of the forum and safety. So those things that they're balancing maybe, and put those together and ask students to make a claim with those terms included or something.
Yeah, absolutely. If those things are bigger, maybe you could have them do some sort of organization. Like these seem to be the big ideas. Can we put these smaller ideas in buckets in those claims there? Could someone build on what Tracy said and maybe have another sort of suggestion how you would help your students sort of make sense of this word cloud? What's sort of jumping out at you in this word cloud?
I think there's a lot of, so it sounds like there's a lot of different words to describe the ideas being expressed here, where you're saying fundamental liberty, fundamental right, your let's see, well, it's moving around on me, but your message, there's a lot of different ways to express the things on the two different sides of the scale.
Yeah.
And that's good, that's fine. And we want to recognize that you may be understanding this concept with slightly different language, but that the principles are the same.
Yeah, thank you for that, John. And I think it's really interesting to have students, again, make this word cloud, and they might use some language that really kind of jives with their schema, the way they're making sense of it. And we can kind of connect that with the academic language, right? Could we hear from one more person about sort of what they're thinking about if their students sort of made this word cloud, how they might use such an endeavor with their students in the classroom?
I think it's, mind you, I teach middle school.
Oh, we need to hear from you, please.
So my perspective is a little different than, say, some of the other teachers.
Uh-huh.
I think that if my students put this together, I would want to dig deeper into what their definition of some of these words are, because some of these words have a practical definition and then they have a legal definition.
Yeah.
And I'm not quite sure my kids would be able to quickly jump on that concept.
Right.
That there's a legal and then there's a vernacular.
Yeah, that's a really great point. And I'm not sure, I taught high school seniors, and I think there might be the same consideration for them as well, Tony. And I can think of even doing something like a Freyer model. If you're not familiar with the Freyer model, where you have the word in the middle, what it is not, they can even make an image that sort of explains the word to kind of just really make sure that they're understanding this vocabulary. So again, this is made by an app called Pull Everywhere. The first few polls are free, but you could also do something in other free educator apps like Mentimeter, or Answer Garden is another one that educators could use. Tony, I saw you unmute yourself. Do you want to add something?
I did. The other thing that I was thinking of is at my kids' age, they parrot a lot.
Mm-hmm.
And I'm I'm kind of cautious when it comes to things like this, because a lot of times they parrot their parents or their relatives or their community, and they have no clue what they're parroting.
Yeah, and I would say, Tony, one of the benefits of Pull Everywhere is you could change the settings so that you have to approve answers before they appear on the word cloud. So you could, sort of screen that a little bit if you think there might be something inappropriate or some sort of misunderstanding as well. You could also, collect these ideas in like a Google Doc, and then you could make a word cloud, like copy and paste it into a word cloud app to do something like this. All right, now we began last week by having you create questions you had about the clause in the First Amendment about the right of the people to peaceably assemble. And you might remember that we came up with lots of questions that you had around that clause of the First Amendment. Some of these questions you asked to Dean Chemerinsky. Some of them maybe you saw answered as you were looking at the case studies in the jigsaw. There might still be some questions that are lingering. So what I want to do right now is I want to just give you a little bit of individual reflection time. And what I'm going to do is I'm going to have you go ahead, and you are going to create a copy of this Google Doc. Let me copy the link right here and I'll put it in the chat for you. Here we are. Boom. So I'm going to have you make a copy of this Google Doc. Open it up in your screen. It's going to ask you if you want to make a copy. You do. That way you can type it in and make your own notes however you want to. And I have listed here on the left all of the QFT questions you came up with. And what I want to do in the next few minutes is I want you to go through this list of QFT questions and simply highlight the ones that you think have been answered already. Like if a student asks me that question, I know the answer. You know, I can tell them the case. I heard from Dean Chemerinsky. I know what the answer is to this. Highlight the questions that have been answered. So I'm just going to give you a couple of minutes to go through and highlight the questions that have been answered. So go ahead and do that right now before we go on to the pair part of this. All right, folks, if you're not quite done, that's okay, because this next step will help you get it done, okay? What we're going to do is we're going to put you into groups. I think you're going to be in groups of 3, actually. And what I'm going to have you do in your breakout rooms is you're going to compare the highlighted questions. Like, see if you guys agree that, yes, we've answered these questions. And if someone has highlighted a question you haven't, you could ask them, wait a minute, I didn't highlight that one. What is the answer? What do you think the answer is? So first thing you're going to do is you're going to compare what you've highlighted. And again, note any items that you can't reach consensus on or answer to bring to the larger group. And then if you have time, if there are some questions that have emerged since we've done the jigsaw, since we've talked to the judicial panel, since we've talked to Dean Chemerinsky, at the bottom, you can add questions to bring to the larger group if you want to. Now, I have a notes section there. That notes section is for you, that if you want to note any information, like a case reference or whatever the case may be, you know, like for later use, like when you do this activity with students, you want to take note of what you want to refer to for the answer. Go ahead and use that note section in a way that fits for you. Does anyone have any questions about what you're going to be doing in your breakout groups? In the words of my grandmother, y'all have your poop in a group and you know what you're doing in your breakout rooms. All right, I got your attention with that. All right, Kathy, let's send them away for about 10 minutes in their breakout rooms. We'll kind of moderate to see how things are going, but bye-bye. I think we can pause recording too for your video editing friends. Maybe I should share with everybody if they don't know. Are we all back? Just about?
Yes. It seems like that's how I'm learning all of my research.
Okay, so here's the hot tip that some people didn't know that asked me, Mary Ellen, how do I share a Google Doc so that everyone has to create their own copy? The way you do it, if you don't know, is once you create the link that you would share with people, after the last hashtag, it'll say something like edit or it'll say view. You erase that and you put in the words copy. And then you can share that with participants or your students where they all have to create their own copy. So that's how you do it. So anyways, maybe that is the best thing. We'll see when they do their evaluations, Kathy. For some of them, maybe that's the best thing that they took away from my part here. All right. So what we're going to do next is we're going to talk a little bit about the lingering questions that are left with the larger group. Okay. So to do this, we're going to have our own little Socratic seminar to do this. And I just shared a document to kind of share a little bit about the norms of this Socratic seminar we're going to have together here. And it's nice that we have a small group, so we'll have some great participation. But again, I'll kind of talk about, I usually have a class size of like 34 kids. So we'll talk about how we navigate that. So again, if you're not familiar with Socratic Seminar, it's a form of student discussion that uses a series of open-ended text-based questions for student-led dialogue. And the goal is really to promote deep understanding of a complex text, like the First Amendment, questioning techniques, and active listening. And the informational texts should provide varied points of views about the topic and kind of be inconclusive. And there are certain rules of engagement that I just sort of shared with you in, that chat box. So again, the rules of engagement for our Socratic Seminar here is basically to thoroughly examine the essential question of this inquiry. We're going to be doing this Socratic Seminar. For the seminar, you're going to be using evidence, preparing your responses, and actively participating in the discussion. And so remember, our question is, how should the government balance individual rights with sort of that common good in regards to the right of assembly and association? Now, the norms of interaction, again, are listed clearly here for students. But what I'm going to do is just give you a moment to skim this document, because I'm going to ask you to use, in particular, these transition statements as we do the Socratic Seminar together, just to see what that feels like, so you would know if you shared this with your students, what it might feel like for them. So let's just take a moment to skim this before we start talking. All right, so let's talk. So is there a question from any of your breakout rooms that you want to bring to the larger group to kind of get a sense of how different people are thinking about that question and how they might answer it? Out loud, preferably.
I'm having screen issues trying to switch back and forth. So in our group, I'm trying to use I guess I don't need to transition yet, do I?
Not yet, but that's fine.
We were very curious about the founding fathers and the fact that they added assembly separately, and we're wondering about the meaning originally. It was different. Something we were pondering in our group.
Tracy, can you talk a little bit more about what you think might be the reason that is?
Oh.
What's your inference?
Our inference was the actual word appearing separately, that it had to be, they were very deliberate as founding fathers as to what was included there. So the fact that it was listed separately, I am inferring that it meant something different than just speech.
Okay. All right, so you can use one of those transition statements to kind of talk about, yeah, we had that same question, or this is what I think about that.
Okay, I have a different transition statement. My transition statement is, and I'm blanking right now, was there anything going on at that time where assembly would have needed to be specified? I'm hoping someone could help jog my memory. I mean, I'm trying to think of what was happening in England just prior, where assembly might have been a hot button that it would have been, and I'm just hoping someone can help me.
Yeah, I'm wondering if it's England or if it's events, because if this is the Constitution, right, then it's really the events of the 1780s, right, versus what's going on in England. So I'm thinking, I mean, right away, I was thinking, are they looking back at like Sons of Liberty stuff? Are they looking back at like Shays Rebellion? Is that what they're looking at? So I'm curious. I teach US, so it's like my primary. So yeah, it's I was thinking about that. I don't know if I have an answer, but I was thinking.
Shays Rebellion is interesting. I hadn't considered that. I was actually wondering about the coercive acts and the shutting down of the assemblies in Boston following the Boston Tea Party, and if that's the reason why they felt the right to assemble was worthy of specific mention.
If
Yeah,
I could add to that as well, I think if we look at, I guess pre-colonial times, pre-1790s, 1780s, or maybe even before, we actually have a United States, a lot of the assembly that happened was largely dubbed illegal. And, at times did turn, I guess, because people didn't have that right to assemble, a lot of these, gatherings ended up turning out violent, I guess. So that's kind of where I'm kind of guessing why maybe they might have wanted to differentiate or protect that right of assembly and association.
John, you want to get in here now?
yes, excuse me. So in my mind, like a more like a layperson's terms, like something you could get thrown in jail for or killed for. So if you said something, you could get thrown in jail for it. If you were somewhere, if you gathered somewhere with other people that, whether they were saying something or not, you could get thrown in jail for just being there. So that would be assembly, and then also publishing something. So I think they wanted to protect separately different things that you could get thrown in jail for, which would be saying something, being somewhere, or publishing something. And those were, we wanted to be clear that those, you were not going to be thrown in jail for those things.
Yeah, it almost makes me think too, John, what you're saying. I like those, and I think students could think about them clearly too, right? Where, also like, were you near this dock where they were smuggling or something like that, right? Or supposedly smuggling. Think about the Vice Admiralty courts and like the law, whenever that was in 1760s, of like, you were guilty, I guess, before, I can't remember all of this, but, or I will remember very soon, but, like the idea of like for search and seizure, like I think there weren't very protective laws for those that were doing, international trade or something like that. So maybe that's a part of it too. But fascinating way to think about it. I like what I just wrote down what you said, saying, being, publishing, right? It makes me think about the Zenger case too.
You just,
Oh, go ahead, Tony.
I was just going to say, you just made me think is something that my kids always find interesting, is that our forefathers actually were considered rebels and rebellion, and they were, because during January 6th, this was a big conversation, and how high, one of the things was, one of the kids asked, well, how is that different than the revolution? And our kids are it's very interesting that we put these forefathers on pedestals, but yet they were the rabble rousers. So a lot of times what they wanted to protect was their own backsides in some ways. And I think that our kids forget that, and we need to bring that to light, like Mr. John said.
I like Cecilia's quote in the chat right now. I was just going to say, Tracy, your question in general and the group's discussion and sort of Jeannie, what you were mentioning, like even being by something that's happening, reminds me, I think it was John or Ryan, I'm sorry, I can't remember, earlier this morning about the idea that like association stays with you even when you're not associating with the people. Like it can, your association with people continues beyond signing the membership list or being at the one meeting. And I think that there is difference to speech in that regards. But then what you say also sticks with you and stays with you too, and it follows you around, as we want to tell young people all the time. So I think it's such a fabulous discussion and such a fabulous question to really try and get your mind around.
Does someone want to use one of the transition statements to transition to another question that your group maybe wants to muddle over with the rest of us?
We had a question about, I think it was Angela and I, about the idea of, you know, when somebody petitions to have a rally, right? Because I remember this was, I think 3 years ago in California, right? When this is in San Francisco, right? When they wanted to have a rally, like a right-wing group wanted to have a rally here, and what was the question on the paper? It was, and I apologize if this was answered the last time, but where is it here? The question, should governments be bound to certain timelines to approve or deny permits for peaceable assembly, right? So when somebody, yeah, I'm curious about that one, because I think I'm a little hazy on how that works. And I'm sure that there's state by state and city by city have certain laws, but I know that if you want to assemble, you need to get a permit, right? So I'm curious about how that, yeah, curious about that.
Hey, Jeannie, just because I posed the question, and Dean Chemerinsky actually had mentioned that, without going into detail, but he did say that there are guidelines, and that basically governments do have to respond to requests very promptly. So just wanted to follow up with that.
That's what I thought too. So cities have to, like, if somebody says, hey, I want to go march on Golden Gate Bridge or wherever, then the city needs to do this by a certain time, because then I would imagine then the groups need to know, are there going to be buses? Do we do this? Can we do that? So I guess it's a city issue.
I think we actually discussed that too, and it was kind of interesting that the concept of promptly, that's so vague, because I used the analogy of a kid coming up the last day of the trimester, handing you all this homework and saying, here, grade it so you can put it in the grade book. What is promptly at that point?
And I think it was Judge Lee and Judge Wood, or Justice Wood, mentioned as well that not just the request doesn't just need to be complied with, but if the request is denied, then there has to be a review of that immediately as well. And so they were mentioning that they have and to use the phrase, here, building off of what's been said, in addition to that, there would need to be the quick response from the legal side of it too, and a review by the courts. Because if it's one thing to get a response quickly to your request for a assembly, say, but if your request is denied promptly, that doesn't do you much good. And so you want to have the ability to say, no, that is an unconstitutional denial.
I think you're kind of getting a sense of how, like, a Socratic seminar after examining these cases might be. And I think you're seeing, at least my students, sometimes they need the language of civil discourse. Sometimes it's not always modeled for them. So having things like these sentence starters, these are more high school sort of sentence startery. You might modify them if you have different populations. But again, giving them that language. Yeah, I would like to add, so there's maybe signage that they could use to sort of indicate where they're at. Thank you, Tony. I appreciate that. She's picking up what I'm laying down here. I love it. Okay. So you kind of get a sense of how that might work. In addition, you could see how just in the little Socratic seminar we had, and I didn't prompt any of you, you brought in prior learning from US history, right? You're bringing in current events like, hey, I think this is like, or hey, here's an analogy from my life, the kid that's turning in the homework late, right? So again, oh, Tony said she got these things from Teachers Pay Teachers and they were free. So maybe Tony, you can drop that in the chat or share it with us later and we can send it out to people. So let's just, before we leave Socratic Seminar, is there one more burning question that you're going to lose sleep over if you don't bring it to the general group here before we move on with maybe some other strategies?
I did have a question, but it was on the it was on a separate matter about the I think the Americans for Prosperity case on whether or not they had standing if they weren't harmed. And I just didn't know if there was going to be options in the future here. Our time left that we have today to discuss it, but
we have some time right now.
Go ahead. Sorry.
I'll go ahead and turn my mic because I really have no idea. But my understanding is that you actually have to have, to be harmed in order to have legal standing in court. And it seems like they're claiming a hypothetical harm in this case.
What was fascinating to me too, because I live in California, and I was thinking when they started to enforce because it seems like the law under, or the Schedule B under question was, it seems like that was on the books, but nobody was doing it. And then all of a sudden in 2010, they started to, if I'm remembering it right, they started to like, hey, let's take this seriously. 2010 is when Jerry Brown was reelected, right? So we had 8 years of a Republican governor. I mean, California goes back and forth, but we did have Jerry Brown. And I'm curious, just thinking, of historical context during this period of time when like it got stricter or whatever, and then it was 2018 that the case was brought to the court. That's when Jerry Brown was still, it was Gavin Newsom was elected, but still, I'm curious if there was anything political to it, all of that, because it was Schwarzenegger Republican, then you've got Brown as Democrat. Yeah, curious about all of that too, and the time frame, Trump's presidency in 2016. How does that play into bringing up this case to the court? So anyways, it was a curiosity being in California and thinking about that. No answers, but just curious.
I think,
John, I would invite you to bring up what you just mentioned in the chat.
yeah,
and maybe expound on that a bit.
I think the majority just cites the NAACP case and saying that it's really the chilling effect that it has on membership. So if they're required to disclose all the members, then it would cause members to not want to be a part or associated because they're going to have their names released. And that was the same, it was directly analogous to the NAACP case. I think that the dissent did a good job of distinguishing why those two situations are very different. However, I think the standing issue is fairly clear in terms of that there would be a chilling effect, but whether it matters ultimately is the more complicated question that the majority and the dissent split on.
I would add, Ryan, what I like about your question, and Jeannie, you're trying to put it in the context of what was going on in the state at the time. I think at least what my experience was in sort of watching this case and hearing the oral argument, there was an expectation that it could have gotten kicked out on standing grounds, that it wasn't a case where they could prove immediate harm, and that the links that the majority went to make the analogy to NAACP versus Alabama certainly surprised some folks. And so, Ryan, your question about the standing really, I think if you dig into that Kagan dissent, she talks about it probably not having, it's a really interesting case because it was one where I was like, on either side, I don't think they're standing. Like California hasn't shown the need for this necessarily because there hasn't been fraud. And on the same token, the nonprofits haven't shown the need for the lawsuit because they haven't had the chilling effect, or they haven't been able to show any chilling. But John, you're totally right that in NAACP they couldn't necessarily show the evidence of the chilling yet. So it reminds me some of the teeter-totter and the balancing that we've been doing in all of these cases, and how do you do that?
Yeah, those would be two good ones to show in teaching government exactly what you're talking about. And kids could really wrap their head around that, I think.
Do we see situations in which the court is looking for cases so that they could jump at the chance to, you know,
I would say it depends on your political lens and what your own view of it is coming into it. I would say in general, Chief Justice Roberts tries not to have the court, this version of the court, get out in advance of cases or political issues. And in general, this current court is one that is most likely to kick things out on standing, mootness issues, procedural issues, so as to avoid sort of wide sweeping changes that they may think is best left for another aspect of government, or for the states to figure out on their own. Whether or not they are successful in that attempt is certainly up for debate. And while I'm being recorded as a staff person on behalf of the American Bar Association, not one I would get to for this conversation, but the next time we're all in person, we can get together and have a cup of coffee afterwards and chat about.
Thanks.
Well, and the Supreme Court decides what cases they're going to hear by vote too. So it's not, it's not like if one justice has a particular axe to grind, they get to, bring up a bunch of cases to try and push that agenda. I agree with Kathy that Justice Roberts does a great job of trying to keep that out of it. But it is, at least I think for the most part, the way it works is they decide on cases to review by vote, essentially.
I think it's a vote of 4 to hear it. Rule of 4. Yep.
Thank you.
All right. So I think you got a sense of, sort of how this could work in your classes. Again, I find one of the most powerful transition statements, by the way, for my students is the transition statements for inviting other people in. My students really get comfortable with doing that, really kind of framing that in, you're kind and you're sending a message that all voices are valued and, you want to hear from them by inviting people in and giving language to a person to advocate for themselves, like, hey, can you come back to me? I'm still gathering my thoughts. That's okay. I think society might be better off if more people took a time to gather their thoughts before responding, right? So even the language to do that is really helpful in making a successful Socratic seminar. So if the Socratic seminar really isn't a fit for you, maybe what are some other choices to sort of have students interact with this material? I put on the bottom here that, there are some variations to Socratic seminar. You could do a divided class where there's like an inner or outer circle. So if I have that large class of 34 kids, maybe I pair them up so they can kind of prep and coach one another to do a Socratic seminar. And then the inside circle can talk, the outside circle can sort of take notes. And, you could have like a timeout where the outside circle coaches the inside circle. This is how you can do better, like, kind of talk them out, and then you can switch roles. And there's also an iteration called Big Paper Talk, which is almost like a silent Socratic seminar that you could also do with students. So that's hyperlinked in this deck for you to look at as well. And again, Socratic seminar, again, it uses that series of open-ended questions really to sort of engage students. Sometimes it's not about really the answers, it's about probing those questions, right? Now, let me share with you, by just sharing a prompt, maybe another way you could approach this material after doing the jigsaw with your students. I might ask you, how should the government balance individual First Amendment rights with the common good or safety? Like, if you're on the court, how might you think about it? Do you think you would weigh in heavily towards individual rights? Do you think as a justice you would weigh in heavily, like somewhat towards individual rights? It would tip a little bit that way? Do you think you would really, it's an even balance? Do you think you would tip a little bit more towards public safety in this day and age? Or do you think you would heavily tip towards public safety? Let's just take a temperature of the room. If you were a justice on SCOTUS and you're getting some of these cases, in the chat, where do you think you might be on this teeter-totter? And you can qualify your choice. If you want to say I'd be 1 in these instances, but 4 in these instances, you can. But let's just see in the chat where you might be. And then I'll explain this protocol. So Kathy, as you look at the chat box, how is the teeter-tottering here? What do you think?
It's a lot of teeter-tottering. I think we actually have most sort of hovering towards the middle with 2. We've got one who says 2 and then 4, so like equal balances on the other side. I think 2 is probably our winning out with some caveats. But I think that there's definitely some concerns being listed about safety with regards to the Second Amendment, or safety sort of in this current environment that we're in. John is also relying on Judge Wood and saying 1 because that's what she said. And she's a 7th Circuit judge, so we follow what she said, which is fair.
Yeah, so this is another discussion strategy you can maybe use with your students, and this is called human barometer, all right? So basically you give students, much like I gave you, some individual think time to respond to the prompt. And I always have them write it down so they don't travel like lemmings with their friends to a certain position, right? So I have them sort of jot down what number or where they are and why. And I might have some kids that are like, can I be a 2.5? Sure, follow your bliss. Just explain why you're a 2.5, okay? And then you have the students take a stand. Now, we did this digitally in the chat box to kind of take the temperature. But if you were in a classroom, you could label the different parts of the classroom and they can physically go to the corners where they're taking the stand. You could put a spectrum up on the wall. You could put the seesaw up on the wall. And maybe they write it on a Post-it note and they put it on the seesaw. And we see like how the seesaw might move, right? Depending on what they say. And then you have your discussion where the students share perspectives, acknowledging the comments of others. So now let's talk about this. And students are encouraged to be flexible thinkers and move if the position changes. If they're going to different corners of the room, if they hear something that sort of modifies their position, I tell my students to physically walk to that other area. Or they can make a new Post-it note and let's put that up on the board. Or if you're doing this like with like a Google Jamboard, they could make another thing and change like where they are in this sort of discussion. If they get more information and they're more solid in their belief, that's okay too. They can add that to their original position. And then you can debrief this. Now, other iterations of this is called 4 corners or philosophical chairs. You could have other variations of this, like you could assign them a perspective, like if you're a police officer, how might you weigh in on this? If you are the mayor of the town, how would you weigh in on this time? You know, if you were a member of the ACLU, how might they respond to this question? So you could assign different perspectives for them to weigh in on. And again, there's a little video here linked from our friends at Facing History and Ourselves of how you might do this online as well. As we go back to school, you know, we were told yesterday we all have to wear masks. There's probably going to be some social distancing. So you might even still want to do something like this online, even if you have the kids back in the classroom, just to keep those social distancing sorts of things going on. Again, for human barometer, the goal of this is to listen to understand. It's not a debate, but a discussion. And some of the norms I put in place are to summarize the point of the previous speaker before you contribute your own view. And again, when you speak, you address ideas, not the people stating them. And to try to use that academic language to agree, disagree, ask a question. Maybe if you did something like that word cloud, you would try to have them weave in some of that language, right, as they kind of talk about this. And again, if someone says something you agree with or your position changes, you can change locations. And again, this really works best when there's some clear choices and when students' claims are based on evidence. and they don't necessarily have a real personal connection to the issue. Like I wouldn't use a human barometer on an issue like Confederate monuments, because that might be really triggering for some of students of color and such, and they might confuse attempts of their peers to persuade them as attacks on their lived experiences, right? So this is better used when you can really use the text evidence to support your evidence, and it's not as emotionally charged for students. And the next one I just want to talk through really quickly that you could have used for this is a structured academic controversy, otherwise known as the SAC, right? Where we could have given one group of students, hey, here are decisions all on individual rights, really supporting that idea of individual rights. Here are court cases that really seem to go on the seesaw for that public safety interest. And you could have the students pair up and write up pro-con presentations from their assigned perspective. And then each pair presents their position to the other two who had the other perspective, and they silently take notes from one another. And then the students could drop their positions and try to generate a consensus addressing the original question of what is that balance? So again, the rules of engagement, when you assign perspectives, you don't have to agree with the perspective you're representing. Your job is really just to convey what you perceive to be the strongest points of that perspective. So whatever side of the seesaw you're on, you've been assigned, what are the strongest points for that side of the seesaw? When you're listening initially, listen to understand, not to respond. And then when the positions are dropped, you try to seek areas of consensus building. It's not a debate. Where can we agree? And again, this works best where there's two clear perspectives, but there's rooms for compromise. When you build consensus, the students can use that text-based evidence in their own lived experiences, and neither of the assigned perspectives would be morally objectionable. Now, hear me now. If you've fallen asleep, pay attention to this next point, okay? This should not be used to deliberate settled issues. Like, we should not be using the SAC to do Dred Scott or Korematsu or separate but equal, right? These are settled issues. We're not going to try to reach consensus between the two sides, right? Okay. So this should not be used to deliberate settled issues, all right? And if you want to see what a structured academic controversy looks like in action, I've hyperlinked actually a video of some students doing it if you want to look at that a little bit later. And I think we kind of experienced already the Socratic Seminar, but I have listed sort of the different steps here for you to investigate later. Okay. Now, a couple of quick tips as we kind of come to a close here. With any of these discussion strategies, I would sort of practice them with maybe a fun topic before doing the academic topic, just so the kids can practice the strategies before you do it with something like freedom of association assembly or whatever the topic might be. So if you're going to do like a structured academic controversy, maybe you could do it on the ever divisive topic in the Chicagoland area, ketchup on a hot dog, yes or no. Or maybe you practice it with this also divisive topics that have torn many a family apart, right? So practice a little bit before you use these strategies to engage your students in further discussion. And if you go to our website, Illinois Civics Hub, if I could just make a really quick plug, we have a link here, current and societal issue discussions. If you want more resources around Socratic Seminar, around human barometer, around structured academic controversy, or even other topics, we have them all hyperlinked there with you, with videos, guides, and instructions, okay? All right, so with that, I think, do we have time for one reflection activity, or Kathy, do you want to just kind of bring it to a close here?
I think one reflection would be nice, Mary Ellen. I know folks may start to drop off, but let's do a reflection for sure.
All right. So I shared with you this slide deck, but maybe we could just do this together right now, and I can capture some ideas here for you. So I was just going to do a little compass point reflection. One question I have for you, and let's just gather some of these here. What are some resources, strategies, or content that you're most excited about using in your classroom from our time together? Unmute yourself and let your voice be heard.
Mary Ellen, in the chat, we've got excited about the jigsaw to see the progression, and then using transition statements. We've also got using the QFT.
Oh, good. Do any of you think you'd use like a Socratic Seminar, an SAC, or maybe something like that human barometer to do this? You can unmute yourself too, it's allowed.
And that pair share was nice to be able to kind of compare with the think pair share.
Thank you, Angela, I appreciate that. Okay, what if anything what do you think, if anything, is worrisome about teaching this content moving forward? Do you have any concerns about teaching this material? And if so, what might they be?
So this was in the chat. It might have also been for excited, but we have has used the human barometer before, but needs more practice.
Okay, cool. Is there anything worrisome about teaching this content moving forward?
If I were in the state of Tennessee, it would be worrisome.
Okay.
Perhaps like some of the extra topics that might come up if you don't feel as comfortable or don't have a solid foundation, it could possibly be worrisome.
Okay.
Just the volume of Supreme Court cases and kind of having an idea of which cases to look at to get to your, I don't know, for great appropriate discussion.
Yeah. And I think Kathy and Tiffany and Laurel that are on this, you know, they're a great resource for this, you know, to reach out to them, to ask them for some ideas.
We would happily put together case studies for you on whatever topic you are interested in.
You know, I have under here and need to know, and I'm wondering, what do your students most need to know about the right to assemble or associate? What would you hope are the takeaway lessons they would get from this sort of lesson or activity? Yeah, Ryan.
I apologize, John, you go ahead.
I was just saying that I actually wanted to just say that I'm a little bit worried that my students are going to use the debate in the House or Senate as a model for their discussion in class. And, you know, these are the issues that we're dealing with, and the examples that they have are not civil discourse. So it's a little tough when you're dealing with that sort of model.
Yeah, absolutely. I mean, I think that's where the transition statements and some of those things in there happen. And also, I did a webinar last week about creating norms for your classroom, like how do you create a civic and collaborative space? And I think that's why it's really important before you even have these conversations to engage the kids in norm building. Like when we have a discussion in here, what does it look like, feel like, sound like, right? What are the norms we're going to use? You know, because our classrooms should be aspirational. Like, how can we do better, right, than what is?
We've, in the comments in the chat, the idea about the need to know that the regulation needs to be content neutral.
How does this information maybe connect with kids' experiences on things like Zoom or Snapchat or curfew laws, even anything like that? Like, what would you hope students would take away after studying this?
We have what is true, what is a right and not a right.
And I think the judges mentioned, and I took notes on some of their, and so citing them directly, that rule of law comes first and that the value of free speech has to prevail. So we don't always like the outcome, but it's so important and we pay a price, and just quoting exactly, we pay a price for that. So I think that opens itself up to, again, that that discourse that can happen. And Judge Lee even gave the example with his 20-year-olds about, well, if I like it. So I think that that's a good takeaway.
Thank you, Angela. And then finally, What are suggestions for future PD? Like today, you know, for this one, we focused on free association and freedom of assembly. If ABA was to do something for you in the future, what are some suggestions of topics for future?
I think for me, I'm coming from an elementary school perspective. So I was a fifth grade teacher for many years, which is why I was drawn to this, but I actually made the grade level change to third grade. So I think having opportunities to bring this to a classroom setting at such a young age, because it's so important and valuable, but having modified lessons or case studies, and I'm sure if I put the work in, I could maybe create a little bit, but I really think it needs to start early. And in terms of this, and I did notice you had some lesson plans. I clicked on one of the links. So I was glad to see that at the democracy site, but maybe a PD that also caters to a younger crowd.
Great, thank you. Any other suggestions for topics of a future ABA getting together? Is there another sort of thing that you would like to explore?
Criminal justice would be good.
Is there anything in particular about criminal justice, like a certain amendment or a certain procedure, idea?
Well, I think it's hard to narrow it down there, but I guess specifically I was thinking about things like sentencing disparity, or systematic racism, stuff like that.
Okay.
I think one of the goals, especially because I'm in middle school, is to introduce them to what a good citizen is, and how that, because we are American citizens, we have these rights, that we have to do our civic duty, including jury duty, voting, and whatnot, and that they are truly an active part of the system, because many of my kids are immigrants. They don't always feel a part of the system.
Thank you.
Mary Ellen, from the chat, we've got a focus on student rights, specifically speech rights, and sort of the immediate future coming out of the BL versus Mahoney case. And then I think that was Tony that was just saying the idea of being active citizens and introducing students to the concepts of active citizenship.
All right.
Oh, and then I've got qualified immunity.
Oh, yeah.
That's a fun one.
Absolutely. All right. So with that, I'm going to stop my share and yield the floor back to Kathy to wrap things up.
Well, thank you, Mary Ellen. Thank you to our teachers on the call. I think that will be a good wrap up for us for today and some reflection. We will be sending you guys an email evaluation and making sure you have the links to the Google Drives and any of the resources that were mentioned, and potentially some additional reading as well. I would give a special thanks to Mary Ellen for being our classroom application and curriculum guide through all of this. She is always such a fabulous support on these programs, and I always come away with many new ideas and strategies. My thanks to Lauren Thiel at the Northern District of Illinois District Courthouse for being such a great partner on this program and the programs we hope to do in the future. And then I would like to thank Bob Zaidman and David Bowen, who did our moderation today, for that wonderful judges panel. They are the two former clerks of Judge Grady's, who you've heard about throughout this, who were really instrumental in creating an endowment to do civic education for teachers and students in the judge's honor. And this is our first kickoff program, and we look forward to doing some in person, and Lauren being able to bring some students to the courthouse and doing tours of the courthouse and talking to professionals there. So we're really excited to have their support going forward for this programming. And finally, my thank you to all of you teachers for persevering through our technology and email glitches and everything else that's been thrown on top of this, on top of the last year and a half of the pandemic life. We are here to support you in whatever ways we can and look forward to future sessions with you. So, thank
And
you
can I take
all.
something really quick?
Yeah.
And thank you, Kathy, for all the hard work you've done on this program. Mary Ellen, same to you. Robert and David, for all the hard work that you did to get us to this point of being able to do programs like this. For the teachers out there, the court is here to support you in any way that we can. We typically do field trips. I usually do 1 to 2 a week, but because of COVID, we're not allowed to do them at this time. So if anybody, while they're teaching things, especially about the topic that we talked about, First Amendment right to assemble and associate, if you guys are able to do anything virtual where you want to have a judge come and talk to your class virtually, please reach out and we'll do my best to work with you to make something like that happen. I have a lot of contacts with the AUSAs and the federal defenders as well. So if you wanted to do something virtually, if you were allowed to, I would love to hear from you and see what we can work out to do for this next school year, just to kind of help support you and, bring the court to the classroom in the only way that we can right now. So I am always here for whatever needs you have, okay? And so thank you so much. And I think that's
everyone. Good luck with the school year. Thank you.
Thank you.
Thanks, everybody.